NIL rules dropped. So I think for the benefit of the audience, because I think not everybody knows, right? NIL stands for name, image, and likeness. It is a series of rules, regulations promulgated by the NCAA. And essentially what these rules mean is that previously, when you were a collegiate athlete, you were not allowed to make money because making money would compromise your status as an amateur. Now, following a Supreme Court decision, the NCAA revised their position on this and issued a regulation that said that you could retain your status as an amateur while making money from your name, image, and likeness as a collegiate student athlete. So this is great news for all athletes, except the ones who are holding an F-1 visa, which was immediately obvious to me because I'm a sports nerd. So I was following this, I don't just follow stuff that's sports immigration, I follow sports. So when this dropped, I was like, uh-oh, we have a problem. And it seemed that nobody had considered it. So back in 2021, when they first came up with this, I was doing my annual installment of the Sports Immigration Conference, and I did a panel on the intersection of NIL with immigration, right? And the idea of the panel was we're going to talk about, like, is it really compatible with F-1 status? And if it's not, what are the other options that might be available? And so Rebecca Sanchez-Voig from South Florida and I were the panelists for this panel, and it was the worst attended panel of the entire conference. There were like 2 people in the room, and like nobody had any interest. Fast forward 4, 5, 6 months later, Oscar Tshiebwe, the Kentucky basketball player, became the poster child, the face of the NIL and immigration problem, right? Because here's a guy who's like, this NCAA phenom, is statistical leader in every category, is winning all these awards. There are all these brands that want to work with him and can't, right? So he's going public and saying, I can't do this stuff because I have visa restrictions. So suddenly everybody's interested in the intersection of NIL and immigration. And so I started tweeting about, hey, why doesn't somebody get Oscar Tshiebwe an O-1 visa? He clearly qualifies, right? Mm-hmm. And the response that I received was just so unexpected. The volume of journalists, stakeholders, agents, NCAA people, they were like, wait, what? O-1 for a college kid? Like, you can do this? And I was like, I've done it before. And I never did it in the NIL context, obviously, because NIL was new. But for a variety of reasons, I'd had, the occasion to do an O and a P for a student who was still in college. These were kids who were actually in a master's program, but nonetheless, they were still in school, right? They were still technically on an F-1 visa. We transitioned them to a P, and they had exhausted their eligibility in college, right, at that point. So this was my test case. This was why I knew it was possible, right? The pre-NIL. So they had exhausted their NCAA eligibility, but they still had scholarship money to pay for their program, right? So they were finishing up the tail end of a master's program, had the F-1, right? But had also signed a pro contract, needed to make money under the pro contract, so needed to transition into a status that allowed work authorization. Now the O&P, per a document published on the ICE website, are allowed to attend school as long as it's, incidental to the principal purpose of the stay, right? So it worked. And I knew that it worked because I had done it before. So when I said somebody get Oscar Tshiebwe a visa, everybody's like, that girl, she knows something about this stuff, right? And that was just kind of serendipity marketing, I guess. And so I realized that there was a demand for answers in this space. I realized that we're working with a patchwork landscape of, NCAA regulations that clearly hadn't even considered the immigration piece of it. You also have an immigration law.
They never consider the immigration component of anything with these laws passed. Like, it's always like,
for sure.
Yeah.
For sure. And then, immigration law is obviously, it precedes the internet, it precedes the digital economy, it precedes social media marketing. It's like, we're working with tools that are of just a different era than the problems that we're facing. And so, a lot of the questions that were coming at me, I was like, I don't know. I don't know what the position is going to be. I can take a reasonable guess. I can tell you that, based on my expertise, this is how I see it. But the fact of the matter is, we don't know yet, because USCIS has chosen not to make a policy pronouncement. They could fix this easily with a policy, right? Congress won't act on any immigration related legislation for obvious reasons, right? There's sort of, the political hot button issue of immigration that prevents any kind of immigration stuff from going through. And so, so you're left with this imperfect situation. So a lot of schools, a lot of stakeholders are coming to me and saying, hey, we've got a brilliant idea how to work around this, right? And of course, these brilliant ideas are just so divorced from the realities of immigration law. So, they'll be like, oh, well, we're going to let them do the work here, but we're going to pay them for it in the home country. Well, no, that's not going to work, right? I mean, the work is here, right? Or, oh, well, they're going to donate all their earnings to charity. Well, they have to have title to their earnings before they can donate them. And immigration doesn't care where you get paid, how you get paid, or if you get paid. It's the service. It's rendering services on U.S. soil that, under this very ambiguous and poorly drafted definition of employment in our statute, I mean, that's a conservative read, right? But as an advocate for my clients, I have to be able to take the conservative position, because I have to be able to anticipate the worst case scenario and to prevent that scenario from arising to the extent that I can. So, the conversation that I'm having with stakeholders, and I had 2 of these conversations, one yesterday, one today, just this is for this week, is that, if we're talking about workarounds, if we're talking about ways that you want to do NIL on an F-1 visa, what we're really talking about is not risk elimination, we're talking about risk mitigation, right? Because at the end of the day, people don't realize this. What I think, it's also being kind of divorced from the realities of immigration enforcement, right? Because they think, hey, we came up with this brilliant workaround. We published an article about it on ESPN. Immigration didn't come handcuff our kid the next day, so we must be good, right? They don't understand that it's going to come up when he files for an extension of status, or when he goes to get his F-1 visa stamp. And the F-1 visa stamp is the part that scares you the most.
Yeah.
Right?
20 years later with the new naturalization, this will pop up. You never know. Yeah.
Right. And and the thing that I keep telling people in this industry is, I'm like, the consular officer is right even when they're wrong, right? Because of consular non-reviewability. So even if they come up with, a way to justify their decision that doesn't comport with, a strict reading of black letter law, you're still screwed because you got your visa denied, right? Yeah. Exactly. And then you can try at a different consulate and somebody may or may not decide to overturn it, right? So there are all these issues in this NIL space, and the book that Amy Maldonado and I wrote kind of goes through a lot of the scenarios that we've been asked about, scenarios that have been reported in the media, and we've kind of analyzed those from an immigration perspective. And I think, if I were to give a Cliff's Notes to the book, it is that, if you're on an F-1, it's probably just not a good idea to mess with it, right? And if you're good enough to transition to the O or the P, it's probably a good idea to do that, right? And Amy, of course, is the brilliant brain behind the Hansel Emmanuel O-1 approval, the one-armed basketball player who came in as a freshman to play in the NCAA. And that was the first known case in the NIL era of an extraordinary ability visa being approved for a college athlete. Since Amy's win, I've also secured 2 green cards and an O-1 for different collegiate athletes, also within the NIL era. So, these cases aren't frequent, but it's an interesting space to work in.